Good afternoon. The Senate Judiciary and Public Safety Committee will come to order. Today is Wednesday, March 19, 2025, and we do have a quorum present. Members, as you can see, we have a long agenda today. We'd like to get done on time, so we're going to try to really tightly focus our presentations and our conversations on the provisions of these bills which are particular to this committee's jurisdiction. Many of these bills are coming from other places as well. So let's keep that in mind and we can be out of here on time. We're going to start off with Senate File 971. Senator Mann, go ahead and give us a brief description of your bill, please.
Thank you, Mr. Chair. Members, Senate File 971 was written after a nurse in Tennessee was convicted of criminally negligent homicide after she injected a patient with the wrong medication, causing the patient's death. This was a nurse who had dedicated her life to taking care of other people, and she had no criminal record. She grabbed the wrong medication that had a similar name to the actual medication that was ordered. She grabbed a medication that started with VEC instead of what was ordered that started with VER. She made a mistake. Being a physician, I know the pressure that I live under and that my colleagues live under to never make a mistake. But because when we do make mistakes, the outcomes can be detrimental. However, healthcare providers are not robots, and by nature of being human beings, we simply cannot go through life without ever making a mistake. And when mistakes are made, we want people to come forward so that we can do what we can to fix those mistakes. If there is a concern that when I make a mistake, I can go to jail, one, people will hide those mistakes, and two, people will not want to be caretakers. They will not want to be doctors or nurses, and we already have a nationwide shortage of both of those things. This bill does not prevent investigation. It does not prevent the removal of a medical or nursing license. It does not prevent criminal charges to be brought if an investigation reveals a crime. It does not prevent medical malpractice suit. It does not provide immunity when there is wrongdoing. It very simply states that when a healthcare provider will not be criminally prosecuted if they make an honest mistake, because an honest mistake should not constitute a crime. With that, Mr. Chair, I have a testifier.
Thank you, Senator Mann. Go ahead and introduce yourself, please, and tell us what you'd like us to know.
Yes, Mr. Chair and committee members, thank you for the opportunity to testify in support of Senate File 971. My name is Adam Carlin. I'm the Chief Nursing Officer at mHealth Fairview Southdale Hospital and the Policy and Advocacy Chair for the Minnesota Organization of Leaders in Nursing. As a nurse and healthcare leader, I'm responsible for ensuring patients receive safe, high-quality care. A core principle in healthcare is just culture, which promotes a culture of transparency and learning rather than blame. When providers fear criminal prosecution for errors, they are less likely to report them, making healthcare less safe. A tragic example is the case of a Tennessee nurse convicted of negligent homicide for a medication error, which was influenced by system failures. Her conviction sent shockwaves through the healthcare community. This mistake could have happened to any of us. Frontline providers make split-second decisions in high-pressure environments, and they must feel safe to report errors to improve systems and to prevent future mistakes. This bill is essential because it encourages transparency in reporting, making healthcare safer. It supports system-wide improvements by focusing on flawed processes, and it helps retain healthcare workers by not criminalizing mistakes. This bill does not protect gross negligence, recklessness, or intentional misconduct. Individuals acting recklessly or with intent to harm will still face criminal liability. Licensing boards can take action against providers for practice violations, and civil actions remain a remedy for patients and families. An unintended error should not make someone a criminal. We must balance accountability and compassion, promoting a culture of transparency and learning to improve systems and prevent future errors, ultimately making healthcare safer for everyone. Thank you, Senator Mann, for your leadership on this issue. I urge the committee to support Senate File 971, and I'm happy to take questions. Thank you.
Thank you, Mr. Carlin. Any other testifiers you have, Senator Mann? Anyone else in the room wish to testify? Mr. Small, come on forward. Go ahead and introduce yourself for the record.
Thank you very much, Mr. Chair, members of the committee. My name is Robert Small, and I'm the Executive Director for the Minnesota County Attorneys Association. First, I'd like to apologize for not meeting the deadline to sign up to testify. I apologize to all of you for that.
You'll have to answer to the committee administrator for that, Mr. Small. I cannot give you absolution, but you're welcome to testify.
Thank you very much. So, members, we have previously communicated our concerns about this bill to Senator Mann, and granting immunity to such a large group of healthcare providers that is contained in this bill is of concern to the County Attorneys Association. First, I would like to communicate to the committee members, we are unaware of any case in Minnesota which has been brought because a healthcare provider made a mistake. We are unaware of that. Secondly, our association values the ability of our county attorneys to look at each particular fact and circumstance of a particular case and the applicable law and make a prosecutorial decision based on the facts and the circumstances of that particular case, rather than a grant of immunity. Lastly, while we appreciate the challenges in retention, recruiting, and retaining personnel in the healthcare industry, that is something that law enforcement and prosecutors are facing as well, and the grant of immunity isn't a solution to that problem. Lastly, the bill covers healthcare providers that are licensed or registered in Minnesota. That covers from, I couldn't find a Z, but I found an X. It covers audiologists to x-ray technicians. It is a huge number of healthcare providers that are registered or licensed in Minnesota. And if this bill does go forward, we would urge that you narrow it. If it's nurses that need this protection, it should be limited to nurses. If it's nurses and doctors, it should be limited, but it shouldn't cover the entire field of healthcare providers registered and licensed in Minnesota. Thank you very much, Mr. Chair, members of the community.
Thank you, Mr. Small. Any questions from members of the committee for Mr. Small at this point? Senator Seeberger.
Thank you, Mr. Chair. I don't have a question specifically directed to Mr. Small. I just was ready to ask questions with regard to this bill whenever the time comes.
Was there anyone else in the room wanting to testify in connection with the bill? Thank you, Mr. Small. Senator Seeberger, comments on the bill?
Thank you, Mr. Chair. I'm familiar with the case of the nurse that you referenced, and I'm also familiar with the case in Colorado of a paramedic who was criminally charged and sentenced to 5 years for administering ketamine in a situation that resulted in the patient's death. And I guess my question is, when I read this, healthcare provider means a health professional who is licensed or registered in the state or by the state. Would this include EMS workers where neither licensed nor registered were certified?
Senator Mann.
Thank you, Mr. Chair. If they are not licensed, then it would not include them. But, Mr. Chair, I feel like under the definition of healthcare providers, licensed healthcare providers, they are included in that definition, but I'd have to ask counsel.
Ms. Primo. Or Mr. Backus.
Mr. Chair, members, I would have to look that up. I'm not, that's really an issue that's more, pertinent in the Health Committee. I'd have to look that up.
Senator
Mr.
Seeberger.
Chair. Thank you, Mr. Chair. I support this bill. I would like to see this bill pass, but I would like it to also include EMS workers. So if we could come up with a definition that includes EMS providers, EMR, paramedic, EMT within the definition of healthcare provider, then I would fully support this bill and ask to be a co-author. Thank you.
Senator Mann.
Mr. Chair, the intent is that it includes all healthcare providers. So I don't know if or registered would include them by definition, but I will double check and make sure that that is done.
Senator Seaborg.
Thank you. Yeah, or registered or, what did I say we were, certified? Yeah, something like that, just to make sure that the intent is to include my healthcare community as well. Thank you.
Senator Mann, the scope of healthcare provider is really more within a different committee's jurisdictions definitions. But council's working on some language to address this if it's the will of the committee. Senator Westland? Oh, I thought you were reaching for your mic. Oh. Senator Kroon.
Thank you, Mr. Chair. This was, I had a few comments, but a question, I guess specifically on relating to the issue that council's looking into right now, because I guess my concern here is I'm looking at the definition of healthcare provider means a health professional who is licensed or registered, but I don't really know what a health professional means. It's almost like circular definition. Healthcare provider means a health professional. And it seems awfully broad to me in terms of what a health professional is. There's a lot of things that are licensed that maybe touch on health matters, but I'm wondering if it wouldn't make more sense to have some statutory cross-references there so we know specifically the universe in which we're dealing with, such as health professionals who are licensed or registered pursuant to statutes, blah, 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 et cetera, et cetera. And so you have a universe of the specific licensees that are covered by this bill, and I'm wondering if that might be a better approach.
Senator Mann, did you have any response to Senator Kroon's comments?
No, that's another approach that would be just as fine. I don't have a preference.
Senator Kroon.
Thank you, Mr. Chair, and not being familiar with that part of the code, I don't have those statutes handy or to make an amendment. It's just an observation that if we're going to be granting immunity to the criminal code, I think the definition should be crystal clear as to specifically which licensees we're talking about, and with a statutory cross-reference. And whether that's this committee or a different committee that should be doing that work, I guess I don't really have an opinion on. But beyond that issue, and I know we spoke briefly on this, and that was before I'd read the bill or fully understood what was going on here. And so I'll admit, I initially thought the bill was to kind of repeal special criminal provisions relating to healthcare providers, which made a lot of sense to me. But now I'm seeing what the bill actually is kind of blanket immunity for general criminal provisions, which does give me some pause. And combining that with kind of the broad nature of the definition. And also, I'm thinking of a slippery slope type of argument here too, whereas if we start granting immunity to healthcare providers, there are other professions where if they make a mistake, they are charged criminally as well, and are they going to be coming to us next to get similar immunity? So I have that concern. And then, as Mr. Smalls said, are we trying to solve a problem that doesn't really exist in Minnesota? I know you referenced the out-of-state cases, but, I don't know what the criminal codes are in those other states and what specific laws they were charged with. But if there hasn't been an instance in Minnesota, are we solving a problem that doesn't exist? Those are my general comments, and then I'm, start wondering what actually is the purpose of this and how could it be construed in unintended ways. But I do like on line .117, what I understand was added, the intentional violation of the law part, I think that was a good amendment. So I'm kind of conflicted on it. I'm not necessarily opposed to the bill. I do think it needs to be tightened up, and we need to think about, maybe in a perfect, we need to be very careful about how we do that, because there should be some sort of criminal intent usually. But if that is a problem, maybe we should be tackling the criminal code itself rather than carving out exceptions for one specific group of people. So those are just my general comments. Thanks.
Senator Anderson.
Thank you, Mr. Chair. Senator Mann, when you say it says healthcare provider means a health professional, could you include a chiropractor or could you include a naturopathic doctor? Is that considered part of that definition?
Senator Mann.
Go ahead.
Mr. Chair, yeah, so if they are licensed to practice whatever they are practicing or registered in the state, then they would be included. I don't know that naturopaths are registered or licensed in the state of Minnesota, but chiropractors are.
Very broad.
Senator Anderson.
That's a very broad category that we're encompassing here with just this small few words that are put in here and trying to put in statute. So I'm a little bit conflicted.
Senator Carlson.
Thank you, Mr. Chair. I have a little, let's say, confusion being a non-doctor, non-healthcare professional, and non-investigator, non-lawyer. I'm thinking, how does this progress if there is a, let's say, a provable incident that happens? And does the healthcare provider get charged and then have to be tried to try to prove that this was an innocent or an unintended outcome, or that the person actually did do a criminal offense? Do they have to be charged first and taken to court?
Senator Mann.
Thank you,
Mr. Chair, so from my understanding is every time that there is a medical error of this magnitude, it's investigated. And it's that initial investigation that determines whether a crime has been committed or if there is a medical error that was done. And then the next steps go from that initial investigation.
Okay,
And
thank
I
you.
will also add from previous comments that Tennessee had never heard of a case like this until it did, right? So I'm very thankful that in Minnesota, we've never had a case like this, but that doesn't mean that one can't happen tomorrow. And what we're trying to prevent is people who are out there doing their jobs and make a medical error for them to go to jail or for them to all of a sudden have a criminal record because they made a medical error. Again, this does not provide, the bill does not give immunity for someone who has committed a crime. But it does, and it does not prevent someone from getting their medical license removed, from never touching a patient again, from having a medical malpractice suit. But we're just trying to prevent a criminal record from being placed on a person who is simply doing their job.
So, Senator Mann, I got to ask a follow-up on that one. You said it does not provide immunity for someone who created a crime, but isn't that exactly what you're attempting to do, is to eliminate criminal liability for certain conduct if it's negligent? I mean, let's say, for example, there was an assault harm for which the intent to commit the act, I mean, to swing the arm, is the criminal act if it results in harm to a person. So, I mean, that'd be a crime. So here maybe the intent to, I don't know, is it Tennessee, the case, but the intent to grab the bottle of the drug, if it turns out to be the wrong one, may or may not be relevant. So, I mean, negligence isn't typically a standard for criminal liability, but there are some provisions in the criminal code, certainly in the driving code, where negligence or the equivalent of it is, or even strict liability. So I'm trying to get my arms around this. I assume in the Tennessee case, there was a jury that heard the case, determined that whatever the standard was for the crime that was charged there was met beyond a reasonable doubt, and that's how the person got convicted. Am I correct about that?
I'm having a hard time hearing you, Mr. Chair.
Oh, sorry. Want me to say it all over again? Last time I call on you, Senator Westland.
Mr. Chair, I've thought that a few other times, but I have not been so bold, so.
If you can't hear me, speak up.
What's that?
I've got the volume if I'm asked to use it, so. In the Tennessee case, I assume there was a criminal charge under some existing statute, may or may not have been specifically related to provision of medical care or health care. When a judge considered whether there was probable cause to proceed under that statutory provision, a jury considered whether there was the burden of proof beyond a reasonable doubt was met. Obviously a horrific outcome. But am I correct in that assumption, Senator Mann?
Mr. Chair, I have no idea. I'm not a lawyer. I was not there. I can't speak to that whatsoever. What I can say is that if we are going to sit here today and say that we're going to allow our healthcare providers in the state to be criminally charged with crimes that could potentially land them in jail when they make medical errors, which every single medical provider in this state will, one point or another, will make in their lifetime. I think that is going to be a really, really powerful statement to make. Because again, I have not met a medical provider in my lifetime who has not made a medical error. That's just not humanly possible to go through life without making a medical error. And for us to say that if you make an error, we're all okay with charging you with a crime, I think that's going to be really detrimental to our healthcare community.
Senator Howe.
Thank you, Mr. Chair. And Senator Mann, I think that what Mr. Small brought up was the fact that I believe that burden would lie on the county attorney to determine whether they're going to charge that or not. And I think if there's evidence there, and I don't believe, you know, I believe in order to make that call, you'd have to go back to wherever this incident happened that you bring up and look at their criminal code and see how it is looked at. I'm a little bit leery of, I think it's up to the prosecutor to have to prove that it was gross negligence or to actually get a conviction like that done. And I think our criminal code, I'd like to think it's tight enough. I'm sure there's some folks out there that are doing some time that made mistakes that ended up where they ended up that never believed in their lifetime that they would end up there either. But, you know, I sometimes think we anticipate things that are going to go bad before they actually do. And without comparing wherever that location was that happened and comparing their criminal code to our criminal code, you know, I'm a little bit, I'm cautious, I'm apprehensive of going there without actually having looked at that and had some folks look at those two different criminal codes and see where it is before we just arbitrarily make an exemption. I mean, I know, you know, yeah, I was an EMT. I'm sure I made a mistake a time or two that turned out bad. we don't know. But I was never charged, and I don't know very many folks that have been, and I'm just cautious of going down that road, and I not that I have a lot of faith in all the all the county attorneys, but I have the faith in most of our county attorneys that they're gonna make the right call.
Thank you, Mr. Chair. Senator Mann, as I review this proposal, I'm concerned also about how broad the language is, a little bit of a lack of specificity. I agree with Judge Small and his comments. But he said something about the frequency of this problem. And if I could surmise, it doesn't seem like this is a major problem that we're trying to solve in the state of Minnesota. And so we've proceeded over 150, 160 years of statehood. And I'm wondering why we need this proposal now as opposed to in the past. Now, being a licensed real estate practitioner in the state, I would love to have a criminal liability-free zone. And quite honestly, we've had other industries come to this committee asking for a liability-free zone. And it hasn't always been criminal, it's actually been in a civil perspective. But I'm one that kind of realizes that anyone in a professional field has a certain degree of standards and ethics that they must perform their duties by. We all realize we're all human, we will be subject to mistake. But nevertheless, I look very dimly on giving any industry any liability-free zone. I would, not that I would need it, but I'm sure colleagues of mine in the real estate industry, and some are pretty slippery, they would love to have a liability-free zone. So they could go out and commit sleight of hand, misrepresentation, fraud. I'd be very concerned about giving any industry that. This is very close to when you look at the healthcare industry, and believe me, I have had relatives and even myself being in the care of professional healthcare practitioners. I have the greatest respect for them. They make difficult decisions, but nevertheless, I'm very hesitant to support any immunity-free zone at all. I could only think that, well, if we're, and I agree with Senator Kroon's comments, that other industries will start piling on. We see that all the time. We see it in our enhanced penalties for what started out as enhanced penalties if you attack a police officer or a building inspector. Now it's judges, now it's prosecutors. Nurses want that. Other professions are coming, and it's every year there's a stack on. And yeah, wouldn't we love to have everyone have an enhanced penalty for attacking me? And I think this would trigger that. I'm sure of it. Perhaps maybe health insurance companies will come and say, we want a criminal liability-free zone too. And so I'm just concerned that this will start a domino effect through all sorts of industries. And we all believe that people in the healthcare industry should live up to high standards, and in my opinion, they do. But I'm very hesitant to support this in its present form. But thank you for broaching the idea with our committee.
Mr. Chair.
Senator Mann.
So, Senator, Tennessee essentially set a new precedent. That's why this bill is coming forward now. A new precedent that, again, if you make an error as a healthcare provider, you can be charged as a criminal. And what happens then is that instead of when you make an error, you come forward, you hide that error. And when people start hiding errors, you accumulate more errors, and we harm patients that way in order to protect people from going to jail. We can't fix systemic issues and prevent further errors from occurring when we hide errors in fear of going to jail. And again, in a medical setting, errors are going to occur, and the only way that we can prevent further errors from occurring is to bring them out into the open and talk about them. But if we hide them, that's not going to happen. If there is a crime that has been committed with willful intent or willful misconduct, intentional violation of the law, gross negligence, all these things, they will be prosecuted to the full intent of the law. This does not prevent someone who has committed a crime from being prosecuted. That is not what the bill does.
Actually, Senator Mann, I think I disagree with that. The whole point is to immunize someone from criminal liability if they have committed a crime that was based on negligent conduct, but not gross negligent or intentional conduct. I mean, that's the main proposition in subdivision 2. So I've been chatting with counsel here a little bit about the language in subdivision 2 about, what does providing mean? What kind of services or treatment does it relate to? It says all of it, basically. And there's no specificity as to any particular crimes that would apply. So anything in the criminal code that's based on something other than gross negligence or intentional conduct would be covered by this immunity provision, seems to me. At least that's the way I'm reading it, and so maybe there'd be a way to tighten that up. But I'm sensing that there are issues relating to the definition of healthcare provider, and I'm getting uncomfortable with the definitions of what kind of conduct it applies to. And we're not going to be able to solve that here and now, right now. So I think the better approach for this here is to lay this bill over, give an opportunity for some of the stakeholders to talk with Senator Mann, and for Senator Mann to consider some of the discussion that we've had today, which I appreciate the looking carefully at the bill. And if folks can get comfortable with the scope of it as it may come back, certainly the definition of health professional is something that's within the Human Services Committee's jurisdiction, on ours anyway. So I'd be uncomfortable sending anything to the floor when that's a pretty significant piece of the bill here, as we've heard. First comment was raising questions about scope. Senator Mann, I know you were anxious to try to do something today and move this forward. I think given the discussion, it's just not ready at this point to do that. So at this point, Senate File 971 is laid over. Senator Mann, don't go anywhere, however, because we have Senate File 1409. It's also your bill. And when we have your testifiers come forward on that as well. All right, members, let's see what folks have to say about Senate File 1409. Senator Mann.
Thank you, Mr. Chair. 1409 is a bill that streamlines marriage records provisions. It removes antiquated data collection, updates fee collection schedules, consolidates definitions of marriage officiants, and streamlines the corrections and forms processes. With that, I'll turn it over to my testifiers.
Thank you, Mr. Chair and members of the committee. My name is Wendy Levitt. I work for St. Louis County and I've worked with vital records for 29, 30 years, and with marriages particularly since 2005 when they came to my office. I'm here on behalf of the Minnesota Association of County Officers and the statewide Vital Records Advisory Committee in favor of Senate File 1409, which is a bill to modernize Minnesota marriage statute. I was going to list all the benefits, but in essence of time, I will just say there's many benefits for the counties and for our customers. I'm going to chat about three different areas. The bill requests several changes to the statute in the Civil Marriage Chapter 517. Three areas that benefit that I'm going to talk about counties and their customers. One of them is we're requesting a couple of changes to 517.08. An important part of the change is to allow for remote marriage applications. During COVID, couples were permitted to complete the marriage application process remotely with the counties. Allowing couples to apply remotely as a way to simplify the process, making it more accessible and convenient, particularly for couples who might face logistical challenges, such as geographical distance, work commitments, or health issues. By facilitating remote applications, counties acknowledge the evolving needs and preferences of couples, providing them with greater flexibility to apply for marriage in a time-efficient manner. Another change in 51708 is asking for the removal of the reduced fee option. The current premarital education discount creates an imbalance in how applicants are treated. Not all applicants or individuals can afford or have access to premarital education programs, which often come with financial and logistical burdens. By removing the discount option, we ensure all applicants, regardless of their socioeconomic background, are treated equally. Couples and their educators have a difficult time meeting every statutory requirement to receive the discount, which includes a statement on the educator's letterhead, applicant's full legal name, specific language regarding the type of education, the educator's signature notarized, and more. It's confusing and it's frustrating for all involved, the educator, the applicants, and the county staff as well. The fees collected for marriage licenses are a vital source of funding for various programs, many of which support important initiatives. By eliminating the reduced fee option, we can increase the funding for programs such as the Minnesota Family Resiliency Partnership Fund. This program would receive $25 for every marriage license sold in the state at the full price. With the reduced fee option, this fund receives only $10 for each license sold at the reduced rate. Removing the premarital education discount will not only promote fairness and equity for all applicants, but it would also help boost financial support for crucial programs which foster long-term community development. And lastly, 517.103 would be a new section of Chapter 517, adding the ability to amend or correct a marriage record. Currently, there is no statute to allow for the amendment of marriage records. We found that with the implementation of Real ID, for example, people are finding issues with using marriage records as proof of name or marital status due to errors contained in the record. For example, Raymond's legal first name is Raymond. However, when he applied for marriage, he used Ray. Now he needs the marriage record to reflect Raymond, his legal first name. While some counties have adopted the amendment process, other counties require a court order. The court process can be both complex and financially burdensome for our customers. Court proceedings require individuals to hire legal representation, navigate the judicial system, which may take weeks or even months to complete. This may be a hardship for individuals and place an unnecessary strain on the judicial system. Allowing marriage record corrections to be handled at the county level would streamline the process significantly. County offices manage and maintain marriage certificates and are well positioned to handle minor corrections in an efficient and timely manner. By empowering the county offices to make these corrections, individuals would have a more direct and accessible avenue to resolve errors without the need for legal fees or court involvement. Individuals would have a straightforward way to ensure their records are accurate, which we find is particularly important for those applying for passports, real ID, or correcting discrepancies for tax or financial purposes. It helps secure the vital records system and reduces the risk of fraud by having a standard, uniform approach to marriage records and changes made to them. Thank you, Senator Mann, for your support. Thank you, Mr. Chair and members of the committee, for your time and your consideration.
Thank you, Ms. Levitt. Ms. Olson, if you could focus your testimony on anything that is, would be in addition to what Ms. Levitt said. Thank you.
Yes, thank you, Mr. Chair and members of the committee. My name is Barbara Olson, and I am here today on behalf of Hennepin County and Mako, and I am here in support of Senate File 1409. I manage the Hennepin County Vital Records Unit, and I'm also chair of the Vital Records Advisory Committee, a subcommittee for Mako, which represents all 87 counties. Today, I want to highlight 3 specific areas related to Senate File 1409 that will benefit local registrars. Local registrars are feeling the financial bind much like other businesses across the state. As a local registrar, we are tasked with the creation, issuance, processing, and the long-term permanent storage of marriage records within our county. Local registrars only receive $25 of the $115 for a full fee marriage license application. We are receiving roughly 20% of the revenue and doing 100% of the work. Our last fee increase was in 2007. The cost to process a marriage license application in Hennepin County is right under $50 an application. But our costs continue to rise to pay staff salaries, their benefits, technology costs, and other incidentals. We are asking for the reallocation of fees to be considered so that local registrars can cover the basic costs for this work now and into the future. We would like $30 to be reallocated back to the local registrar from the general fund, raising the fee to local registrars to a total of $55. We are also asking to eliminate reduced fee marriage license applications. I won't go into that any further because Wendy did touch on that particular piece. We are also asking for a fee increase for marriage license certificates to $20, up from the current fee of $9. The last time we received a fee increase was in 2005. Local registrars are required to send out one free marriage certificate to the applicants, and our operational costs continue to rise with postage and security paper. This change, along with the reallocation I mentioned, will help counties across Minnesota continue this critical work for our residents, putting undue burden on local property taxes. And the last item I want to touch on today is regarding marriage officiants. When Chapter 51704 was amended in 2023, it opened up marriage officiating to anyone over the age of 21 who registered as an officiant with the local registrar. That pathway was added to existing pathways for officiants. The result is there is a higher scrutiny with documentation needed for certain religious officiants than the average person, and a lower barrier for judges and other specific faith communities. We are seeking one equitable pathway for anyone over the age of 21 who registers as an officiant with the local registrar. This administrative cleanup of language will clarify and streamline the application process and provide a fairer standard. Thank you for consideration of Senate File 1409 today. Thank you.
Thank you, Ms. Olson. Members, the plan is to lay this over because there needs to be some work between the author and Senator Westland and perhaps others with regard to how the fees get handled, and there's some overlap on bills that are being proposed for us today. Anyone else in the room wish to testify in connection with this that would add something that hasn't already been covered? Not seeing any questions or discussion. Senator Anderson.
Thank you, Mr. Chair. Just maybe some clarification from council. On line 2.16, it says, the county where the civil marriage officiant is registered must be endorsed. Counsel, can you give me a better idea of what must be endorsed? Could that be just written upon and recorded with each certificate, or is there a better way to me, I don't really understand must be endorsed. Who's endorsing? Is it the county that's endorsing, or?
Ms. Primo?
Mr. Chair and members, I believe that's saying that the marriage, the county where the marriage was submerged is run, that the certificate must reflect some sort of indication, official indication about the county where that civil marriage officiant is, has filed for their official paperwork. So I think this is a requirement upon the counties, although it's not clear.
Maybe Senator
Senator
Mann.
Anderson, I think Ms. Olson is leaning forward like she has something to add. Ms. Olson?
Mr. Chair, Senator, that is correct. Each county is required to put on the actual certificate where those credentials are filed.
Senator Anderson?
Well, it just seems like it must be endorsed. Seems like it just, if it was written or something like that, would be simpler language to. And then another question I have is, what is considered a uncertified marriage? Back on page 6, talks about the fee for an uncertified marriage record versus a certified marriage record.
Ms. Olson?
Mr. Chair, Senator, basically, it's just a marriage certificate or a marriage record that is uncertified. It does not have the documentation that it came directly from the county seats. Currently, we would always suggest that you get a certified copy, but uncertified copies are available.
And who, Mr. Chair?
Senator Anderson?
Mr. Olson, who gives those certificates that are not certified?
That would be from the county as well, from the local registrars.
Really?
Yep.
I hadn't heard of that. Thank you.
Senator Limmer?
Thank you, Mr. Chairman. On line 1.18, there's language that strikes the words date and place of birth. And I see that partially it comes up again on page 2, lines 23. It makes reference to full ages. That's existing language. And then it includes dates of birth, but it omits the place of birth. And I was wondering why place of birth is removed.
Mr. Chair, Senator.
Ms. Olson?
That particular piece falls under the report of marriage, section 144.223. That is information that previously, years and years ago, probably 25, 30 years ago, the Department of Health asked us to collect. We no longer collect it. The Department of Health no longer wants it. They don't need it. So it's just irrelevant data. So we would not be collecting that moving forward.
All right. Mr. Chair,
Senator Limmer?
the only reason I pointed at this is in the backdrop of a lot of discussion regarding immigration, that might be useful in the future. But it's good to know why it was originally omitted from the bill. Since we're not taking action on it today, Mr. Chair, I'll just hold any other questions. Thank you.
Senator Westrom?
Mr. Chair, similar questions, Senator Mann or to one of the testifiers. So we're getting rid of the section that looks like that requires the sex to be identified on the marriage license as well. What's the reason for that? And the current process looks like if it's a remarriage, they have to use their prior last name, but now we're just saying they'd use their last married name. Is there a benefit or a reason that we may want to know the prior names if you're ever trying to track some lineage or other information on who's who or a person? And then does this, I think in Minnesota, you have to be divorced before you can remarry, but
Yes.
does this leave us with a situation of maybe somebody can be married before they're divorced, and maybe that's already allowed, and I'm wrong on that fact, but I don't think so. But can you comment on those changes as well?
Ms.
Mr.
Levitt.
Chair. The previous married names are collected, and the reason for that, I'm not exactly sure. If it has to do with child support and marriages do have to be, the divorces do have to be final before they apply for marriage. I think it's just a way to track name changes through the process. People can change their name through the marriage process, and it's just a record-keeping kind of a step.
Ms. Olson.
Mr. Chair, Senator, it is just basically record keeping. We only asked for the last previous name, only because, I'll be very honest with you, a lot of applicants don't know their previous names from previous marriages. It's very difficult to collect all that information, but that is its record-keeping purposes.
Senator Westrom.
Mr. Chair, so how do you go about knowing if there was a final divorce before somebody would remarry? Is that something you check, or is that not something that happens at your process?
Ms. Levitt.
Mr. Chair, we do not check. Applicants do complete those applications. There is a statement on the bottom, and we also give them an oath that they are providing all the information, that all the information that they're providing is true and correct.
Okay. So it's all based,
It's
Mr.
based
Chair,
on
it's all
them
based
being
on
honest.
penalty of perjury or
Yes.
an oath that this is the honor system?
Correct.
Okay. So you said some people can't remember their last name. Can you expand on that? I find that hard to believe. If you were married before and your maiden name was Anderson, really? People wouldn't remember 2 or 3 names back?
Mr.
Anderson, Johnson, they all sound the same to me.
Mr. Chair, Senator, yes,
Olson.
if there are instances where somebody's been married 2, 3 times, they do not remember previous last names. They forget their names. We deal with name changes consistently, and there are difficulties remembering.
And Mr. Chair.
Ms. Primo has something to add, Senator
Okay.
Westrom.
Go ahead.
Mr. Chair and members, looking at lines 2.24 to 2.25, the obligation to provide a party's married name is being clarified to refer to the most recent marriage, as opposed to maybe potentially other marriages before, because the only maybe legally relevant name when you're getting married again is what your name was in the most recent marriage. And
Okay.
at least that's how I understand the intent for that change, so that the parties don't have to provide those previous, even older, like marriages information.
All right. Last
Senator-
question, Mr. Chair.
Yes, Senator Westrom.
So, Mr. Chair, and I guess to one of the testifiers, so if somebody was here and didn't have legal status, would you know that at all, or would they be able to just give you a name? And I guess, is that some of the reason you may not get prior names at all, or do you come across those instances or experiences at all, or not in your line of work?
Mr. Chair.
Ms. Levitt.
Senator, Legal status, do you mean the country, a U.S. citizen legal status?
Yeah, correct.
Okay.
Correct, or if they're
Senator
from
Westrom.
Guatemala or some other country legally, do you know that?
Currently in Minnesota,
Levitt.
you can come from any country and apply for a marriage license here in Minnesota. The only thing we're going to require is that that ceremony take place in Minnesota. When people don't have social security numbers, they do have to verify that on the application that they do not have a social security number. But it's okay if they are from another country and wish to get married here in Minnesota.
Mr. Chair, the last
Senator
part I
Westrom,
didn't
you
quite
already
hear.
said last question.
What's that? I did, but I didn't hear the last answer to the last question. The last sentence you trailed off, so if you could restate the
Ms.
last
Levitt.
question.
Sorry, individuals can travel from outside of the United States to Minnesota and apply for marriage here. It's not a requirement to be a Minnesota citizen to apply for Minnesota marriage license. The only requirement we have is that the ceremony take place within the geographical boundaries of Minnesota.
Senator Howe. This will be the last question, then we're going to lay the bill over.
Thank you, Mr. Chair, and I just have a question on 4.8 to 4.28. I believe that piece in there, I understand that it's a kind of a troubling piece to track, but that was in there to provide and try to cut down on the divorce rate that we had. Do you have any documentation whether that was successful or not before we delete that out of the system? Whether the people that have gone through that premarital education do have a lower rate of divorce than those who have not gone through that premarital training? Being someone that does that kind of stuff, I'm just concerned that before we throw out a successful piece of that does good work in our society, that we're going to throw that out just because it's a bookkeeping problem.
Ms. Olson.
Mr. Chair, Senator, we don't have specific numbers on if it was successful or not. Part of the testimony that I did not talk about because what Ms. Levitt talked about reduced fee marriage license applications. Part of the concern that we are seeing has to do with potential fraudulent use. There is no checks and balances about receiving this reduced fee marriage license application, and we want to stop any fraudulent use.
Senator Howe.
Sorry, Mr. Chair. So you're telling me that someone's going to do the fraud for the difference of a 115 to 40? And you've got an officiant that's going to go through the work of, well, okay, I can see that could happen, but I can see that it probably wouldn't be a huge piece of, okay.
There being no further questioners on my list, we're going to see it again because it's going to be laid over. So, members, we are now laying over Senate File 1409. We're going to move to, see here. Okay, Senator Utke, we're going to take up your bill, House File 129 here. I've been told you're in the room. There you go. Members, the bill is being passed out. I'm not aware of any testifiers that have signed up here. Senator Utke, when you're ready, just give us a brief description of your bill, please.
All righty. Thank you, Mr. Chair, and I will give you just a brief overview of the bill. Members, this bill requires the Director of Child Sex Trafficking Prevention to submit a program evaluation to the Legislature. This statute falls under the Sexual Assault Victims Statute, and the program evaluation that is our topic of discussion today involves Safe Harbor for Sexually Exploited Youth Statute. The Director of Child Sex Trafficking Prevention is responsible for the development and providing comprehensive training on sexual service professionals, medical professionals, public health workers, and criminal justice professionals. The director is responsible for collecting, organizing, maintaining, and disseminating information, monitoring and applying for federal grant programs, managing the grant programs and the requests for proposals for these grants, identifying best practices, and conducting comprehensive evaluation of the statewide program for safe harbor of sexually exploited youth. Youth 24 years of age or younger are eligible for all the services and supports. Back to the language of this bill, it's simple. This bill just adds that the director must submit the updated evaluation to the chairs and ranking minority members in the Senate and House of Representatives committees with jurisdiction over health and public safety in each odd-numbered year. Currently, the director only had to submit the evaluation to the Commissioner of Health. So we're just adding that that report comes to the ranking members of Health and Public Safety.
Thank you, Senator Utke. Any questions? Any members of the committee? Not seeing any. Senator Kruen moves that House File 129 be recommended to pass and be re-referred to the Senate Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Utke.
Thank you, Mr. Chair. I tried my best to get you back on schedule.
Thank you. This is going to be a tough one. We're going to go to Senator Howe, House File 286. We have two online testifiers. Members, the plan is to move this on to the State and Local Government Committee. Senator Howe, please give us a brief description of your bill.
Well, thank you, Mr. Chair and members. This bill, what it does is it basically allows the cities and counties to do a more thorough background checks on certain businesses and especially those massage services or cabaret. We've, in a small jurisdiction where I work, we've had a number of issues with sex trafficking inside of some of these businesses, and when they apply for the license, we'd like to do a more thorough background check through the federal instead of just the state system. And with that, I'll go to my testifiers that are online to expound on the situations that we faced.
All right, Chief Resnicek?
Thank you, Mr.
Did I say
Chair.
it
I'm
right?
Anthony. Yes.
Welcome to the committee, Chief. Go ahead.
Thank you, Mr. Chair, committee members. I'm Anthony Resnicek. I'm the Chief of Police for the City of Way Park. This House File 286 is coming before you to help fix an ongoing problem that's statewide. Way Park, like many Minnesota cities, has a city ordinance which allows us for local licensing of therapeutic massage establishments and massage therapists. Just for 2025, Way Park has 17 licensed massage therapists in our jurisdiction. The current background process requires us to use a purpose code E. When using this purpose code E, it is specifically for licensing and child services for local licensed vendors and for employment for non-criminal justice positions. Purpose code E, and the problem that we find with it is it only allows us to see adult arrest data that is less than 1 year old and any adult convictions, but only in Minnesota. As cities are currently being charged with trying to help regulate the massage industry in our local jurisdictions, we get such a narrow glimpse of that person's character or past behaviors. The proposed change would require a full fingerprint a full fingerprint-based background check to be conducted. This would be a much more thorough vetting process that would tie all past criminal history and behaviors related to this licensing background process. It would ensure that massage therapists are truly being vetted. It would help ensure that discrepancies such as using different names, having out-of-state conduct or prior cases that have been pled down or dismissed would actually be found and could be vetted by the local municipality to ensure we are licensing, quality applicants who have the proper credentials and background. I feel the proposed bill would clear up some loopholes that are currently facing the licensing process for this industry across the state. It would aid us to ensure that that licensed therapist truly has been vetted and is shown to be a true professional in the massage industry. Mr. Chair and committee members, thank you for your time.
Thank you, Chief. We also have Dave Bentrud remotely to testify. Mr. Bentrud, go ahead.
Yes, Mr. Chair, thank you. Can you hear me okay? I had to jump on my cell phone to be able to listen in.
Yeah, that's fine. Just identify your affiliation and go ahead.
Sure. I'm Dave Bentrud. I'm a retired police chief for the city of Way Park. So Chief Resicek's predecessor there. We worked together for several years. I think the only thing I can really add is that when we were early on investigating a lot of the sex trafficking and how that problem manifested itself, the massage industry started to explode in our community. When we started looking into the backgrounds and some of the applicants for those positions, we started taking applications, or licensing rather, massage therapists starting in about 2019 when we passed a city ordinance allowing for that. We found that several of the applicants were submitting fraudulent transcripts from their schools that they were alleging to have attended. In some cases, they were vacant lots in Los Angeles, et cetera. So the ability to be able to properly vet massage licenses or applicants is, as Chief Resicek shared, is really critical. And we need to be able to do it on a more nationwide basis. We were using a commercial product to be able to do some basic national credit history, or not, well, credit, but also criminal history. And it was very limited. And so the ability to use the state system to have fingerprints to be able to facilitate that is only going to help and really, I think, protect those massage therapy that are legitimate and help us to prevent illegitimate or illicit salons to develop. So I'm supporting this bill, and I appreciate the opportunity to testify this afternoon.
Thank you, Chief Bentrud. All right, any questions or comments from members of the committee on Senate File, House File 286? Not seeing any. So Senator Limmer moves that House File 286 be recommended to pass and be re-referred to the Committee on State and Local Government. All those in favor say aye. I'm sorry, I could have done Senator Howe. It's his bill.
I will say, just to expound on the problems that we've had is that
You're about to get your bill passed, Senator Howe.
I know, but I just feel it's important
But
there was 1 year out of 4 massage parlors in the city of Waite Park. We closed down 3 of them doing sex trafficking. And I just want to expound on the fact that sex trafficking is, if you don't think it's in your back door, it is. So thank you.
Well, I know it's not in my back door, backyard maybe. Senator Limmer withdraws his motion. Senator Howe can take his chances. Senator Howe moves that House File 286 be recommended to pass and be re-referred to state and local government. All in favor say aye.
Aye.
And opposed? Aye. Motion prevails. All right, Senator Limmer, we're going to go to your bill here, name changes. Senate File 1653. Members, the plan here is to lay it over for possible inclusion. Senator Limmer.
Thank you, Mr. Chair. Senate File 1653 is a bill that's initiated by the Minnesota Sheriff's Association to ensure that permit to carry records remain accurate and up to date. In doing so, it improves law enforcement efficiency and public safety. As a reminder, the Minnesota Personal Protection Act was enacted in 2003, with permits first eligible for renewal in 2008. Under Minnesota's Personal Protection Act, sheriffs are the only authority responsible for issuing, renewing, and revoking permits to carry. They conduct thorough background checks utilizing FBI, BCA, and Department of Human Service records to ensure eligibility. Permit holders are already required to notify the issuing sheriff if they change their address, but there is no requirement to report a legal name change. This creates a gap in law enforcement records that could lead to verification issues during encounters with permit holders. This bill closes the gap by ensuring the accuracy of permit to carry records, which ultimately promotes public safety. With me today is Jason Camerud, Carver County Sheriff, and he would like to give brief testimony, Mr. Chair.
Sheriff Camerud, welcome to the committee. Please go ahead.
Mr. Chair, members of the committee, I appreciate the opportunity to be here to talk to you today. I'm Jason Camerud, Sheriff in Carver County, and I am here today on behalf of the Minnesota Sheriff's Association. And you might recall the Minnesota Sheriff's Association does represent all 87 sheriffs in the state of Minnesota. As Senator Limmer stated, the sheriffs are responsible for the review and processing of permit to carry applications. In 2023 alone, Minnesota sheriffs issued roughly 65,000 permits statewide, according to reporting from the Bureau of Criminal Apprehension. My own agency, we issued roughly 1,100 just last year. So if you're kind of trying to get a gauge of how many per sheriff, that's where my agency was at. Current statute requires permit holders to notify the issuing sheriff within 30 days of a change of address, but there is currently no provision for a name change that would require them to notify the issuing agency. This bill simply adds the name changes to the existing notification requirements, ensuring that law enforcement records are current, accurate, and up to date. Having current and correct information is critical in the law enforcement world. When we encounter an individual carrying a firearm, it's very important for us and for public safety that we be able to reasonably quickly verify the permit status and to not detain that person any longer than is necessary to sort that piece of the contact out. If a name change is not reported, of course, the name on the permit may not align with the name of the subject, and it creates delays, unnecessary confusion, and potential enforcement challenges. I think that this bill, as written, is what I would categorize as low-hanging fruit. It should be a reasonable, straightforward solution, simply requiring the folks to notify the sheriff, the issuing sheriff, of the name change within 30 days. The consequence for it is a petty misdemeanor, so it is a pretty low bar and just a little bit of an incentive to encourage them to do it. It's not overly punitive, in my estimation. I think that I can say with pretty high level of accuracy that all of the sheriffs are interested in having their records of the permits that they've issued be accurate. It improves our efficiencies, maintains consistency in permit regulations, and therefore the Minnesota Sheriff's Association supports passage of Senate File 1653. I appreciate your time and willingness to hear me out on this, and I would be happy to field any questions if you had any.
Thank you, Sheriff Cameroon. Any questions on this matter? Not seeing any. Any closing remarks? Senator Limmer?
Mr. Chair, I think the bill is fairly straightforward. I don't think we need to discuss it anymore. I would appreciate the committee's support.
Senate File 1653 is laid over. Thank you. We're going to go back to Senate File 1734. Senator Klein. Thank you for your patience, Senator. I know you've been going back and forth between here and another committee obligation as well. Minnesota Business Filing Fraud Prevention Act. Senator Klein, let's see here. This is our first committee, and we have some authors' amendments, it looks like. All right. So, Senator Seeberger, there's an A1 and an A2 amendment. If you'd be willing to offer the A2 amendment and incorporate the A1 language into the A2 amendment, that would be an appropriate author's amendment motion. Would you do so? All those in favor of Senator Seeberger's motion say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Klein, tell us a little bit about your bill, please.
Thank you, Chair and members, for hearing the 1734 and for your time and generosity in adopting the author's amendments. I have with me representatives from the austere Department of Secretary of State to support this bill, and they presented it to me. Let me tell you about it. Chair, the Minnesota Business Filing Fraud Prevention Act is an important step in protecting Minnesotans from business identity fraud. As Chair of the Commerce Committee, I'm proud to chief author this as a significant consumer protection measure. Bad actors can hijack a legitimate business or create fake ones in someone else's name, often chosen by chance with no connection to the perpetrator. Victims often don't realize what's happened until they're facing bills, legal trouble, or tax liabilities for a business they never owned or for actions their actual business did not take. The Office of the Minnesota Secretary of State handles phone calls daily from Minnesotans who are suddenly dealing with this crime without a clear answer of why and how to clear their name. The office also lacks, at this time, the statutory ability to help beyond aiding law enforcement who may investigate. Article 1 of this bill creates a clear process for handling fraudulent filings, making it easier to literally set the record straight and unwind the damage. It's near impossible to pass laws at the speed that criminals can abuse systems, and having a direct path to challenge and remove wrongful filings ensures that victims can reclaim their businesses and identities without long delays and costly legal representation. The faster fraud is addressed, the less damage it can do via further criminal activity acquiring loans or equipment in the victim's name. The Minnesota Business Filing Fraud Prevention Act ensures that those affected by fraudulent filings have a straightforward way to fix the problem and to move forward. Protecting business owners and individuals from fraud strengthens trust in the system and keeps Minnesota's business community strong. Article 2 addresses a separate problem faced by the office. Another common issue, the office receives calls from about business owners across the state, solicitations offering to complete operating requirements for a fee. The office has seen examples of solicitations that looked nearly identical and could be mistaken for official communications from the Office of Secretary of State. This can easily deceive business owners into paying for a service that they could do for free or for lower cost simply by going to the office's website. Mr. Chair, with your indulgence, I'll turn it over to Ms. Bethke, Deputy General Counsel at the Office of Secretary of State.
Ms. Bethke, welcome to the committee. Go ahead.
Thank you very much. Good afternoon, Mr. Chair, members of the committee. My name is Lauren Bethke, and I'm the Deputy General Counsel for the Secretary of State. We've been working on this concept in Article 1 for a couple of years and consulting with other states and stakeholders. We're really pleased with the shape it's taken. There are a few letters of support, I believe, in your packets. So thank you very much to Senator Klein for carrying the bill, and thank you all for hearing the bill today. I will start by going through the bill pretty quickly, but be happy to take questions afterwards or go into more detail on any aspects of it. So as Senator Klein mentioned, the main portion of the bill creates a process for our office to be able to remove fraudulent filings from our business filings database. Right now, we don't have the authority to remove a fraudulent filing unless someone goes to court and gets a court order directing the office to take that action. So this bill would create a process that allows us to do that after going through some steps to ensure due process. And I'll talk about those steps pretty quickly. The first step is that a person would contact our office and make a declaration of wrongful filing. So they would explain, this is who I am, this is what the filing is, and this is why I'm saying that it was filed wrongfully. Our staff would review that declaration and then give notice to the complainant, the person who filed the declaration, and the filer, which is the person that made the original filing. The notice would describe the complaint and explain the process and timelines and kind of consequences of not responding. Once the notice is given, the filer has 21 calendar days to respond. If they don't respond, we would presume that the filing is fraudulent and issue an order. I'll talk a little bit later about what the next steps are when that happens, but that's the first notice and opportunity to respond. And I'll just note that in other states, it has been the case that a lot of complaints end at this stage because it is kind of a numbers game for some of the folks committing this fraud. They're making a lot of fraudulent filings related to a lot of businesses, and they don't always attempt to defend them. They'll just kind of move on to the next. If the filer does respond, though, we take a look at their response, make a preliminary determination of whether the filing is fraudulent or not. And then we would give notice of that preliminary determination. So that's the second notice period. And the non-prevailing party would have 10 days to respond. If they don't respond, the preliminary determination becomes final. And if they do respond, we again consider the information they've provided and make a final determination. If our staff does determine that a filing is fraudulent, we would issue a final order explaining the rationale for that decision. And we would also mark the filing as fraudulent or unauthorized in the business filings database and redact any names or other personal information that was used without authorization, so it would no longer be displayed on those documents in the public database. We could also take other actions to reduce the risk of further fraudulent filings. For example, we could lock online filings for the business for a period of time. And that would be done on a case-by-case basis after consulting with the complainant. If our staff determines that a filing is not fraudulent or if there's not enough information to make a determination, we would issue a final order, again explaining that rationale, and in that case, the filing would stay in place in the database. In either situation, the non-prevailing party could appeal the order in district court, so there is an option for judicial review of our office's determination on these filings. So that's kind of how the overall process works. There's also a section on classification of data, which is amended by the author's amendment. The underlying language is basically reorganized in the amendment, but it clarifies what data is public and what is not public. And then the amendment also clarifies the ability for the office to share data with the Attorney General and a person or agency if it relates to a criminal or civil investigation. Article 2 adds a section that addresses another problem, which is the deceptive business mailings. We have found that there are folks out there sending solicitations to businesses and saying, you need to make this filing and pay us a fee to make the filing for you. We certainly have no objection to a business providing that type of service for a fee, but the issue is that the solicitation often looks really basically identical to a communication from our office. So it can be very easy to mistake that for an official requirement. And so people will end up responding to that solicitation and paying a fee for something that they could do easily themselves on our website. So this section in Article 2 has some requirements for this type of solicitation. Folks can certainly still offer this type of service, but they just need to make it clear that the document they're sending is an advertisement and not an official government communication. And then Article 3 just includes a few conforming changes to add cross-references in chapters 13 and 609. So that's a high-level overview, but happy to take questions or go into more detail. Thank you.
Thank you, Ms. Bethke. Any other testifiers on behalf of this bill? All right, Senator Westrom has a question. Go ahead, Senator.
Mr. Chair, how common is this? And my understanding, this would be giving the Secretary of State's office sole authority to make these changes with this process. It looks, there's a 21-day turnaround and then a 10-day turnaround to finalize the decision, or I guess can you explain kind of that authority, and is this final and ultimate, and what if you get it wrong? How does a party that's not fraudulent, get caught up in being called fraudulent, how do they remedy it as well? If you can kind of talk through that system a little bit more.
Ms. Bethke.
Certainly. Thank you, Mr. Chair, members. So I'll start with your first question, Senator Westrom, which is how often this is happening. It's a great question. We don't have a specific number because right now we can't really do anything in these situations, so we don't necessarily track when folks are contacting our office. I will say anecdotally, we are getting certainly multiple calls per week and often multiple calls per day on this type of issue. So I would say anecdotally, it does happen quite a bit. Colorado is a state that has a similar type of program, and they have a similar size business community, similar number of business filings. And in the year after they implemented their similar program, they had 1,800 complaints made. So we're anticipating that the numbers would be reasonably high. In terms of your question about our authority and how it works, if a legitimate business filing gets removed, what's the situation there? In terms of the sole authority, yeah, as you go through the process, the Secretary of State's office would be the one, making the decisions in terms of whether the filing is fraudulent. Certainly, a person who disagrees with the ultimate decision could appeal it in district court. But if a legitimate business filing were to get removed, this actually is something that we've talked about with stakeholders. The business would be able to simply redo that filing, is one option. They certainly could also appeal in district court. But we actually think that's pretty unlikely to happen. The way the process works is when the initial complaint is made, our office takes a first look at it, and we would have the ability to reject it if we think it's being made to harass the business or it's being made for an illegitimate reason. And based on the experience of other states, fraudulent filings we've found tend to follow certain patterns. And so we feel pretty confident that our staff on that initial review would be able to weed out, a lot of those kind of illegitimate complaints that you mentioned.
Mr. Chair, it sounds like from your answer, if somebody wrongly got caught up in this process, you said they could refile. Would we not, Senator Klein and Secretary of State, maybe want to add some language in here that would rather clarify that if somebody's right, that they're able to use the original filing rather than put the burden back on the same business filing to say, well, I guess we got it wrong the first time, but redo it, and everything you did in this 3-month or 6-month period isn't under your corporation or LLC. Shouldn't we? I mean, if they've filed and they turn out legitimate, shouldn't we just allow the filing from the date it was filed as language in this process? I think what you're trying to get at is probably, unfortunately, a growing issue that we need to deal with. But I don't want to sweep up more than we're intending to sweep up here or make it more difficult for parties. Can you see where I'm going with this question, or does that not make sense?
Ms. Bethke. Or Senator Klein.
Senator Westrom, Mr. Chair. So I guess, first of all, I would just say that the process for sort of being evaluated for a fraudulent filing seems fairly careful, repetitive, and comprehensive to me. They have this initial notification that they have the opportunity to respond to. If they feel like the judgment has been made in error against them, they have the opportunity to submit additional evidence. So I guess in my own conception, the odds that someone would go through that entire process, be declared a fraudulent filing incorrectly, seems quite remote. What I think you're asking for is, if we get it wrong and we know we got it wrong, can we have language in here that immediately reverts them to their legitimate business status? And I guess I would maybe turn that over to the testifier.
Ms. Bethke.
Yeah, thank you, Mr. Chair, members. Yeah, I think that is certainly something that we can continue to develop as the bill moves through the process. This won't be the last committee stop. I will just say that we really endeavored in putting this process together to balance the need for this kind of extensive procedural due process against the need to get these issues resolved pretty quickly. Because when folks are making these when folks are making these complaints, the fraudulent filing is out there. Sometimes folks are, making illegitimate, they're applying for bank loans using this illegitimate information, or they're filing tax returns in the name of these businesses. And so, yeah, it really was a sort of balancing act that we were trying to do, but certainly open to continuing the discussion through the process.
Senator Weston.
Thank you, Mr. Chair, and thank you for that. I'd certainly be interested in working with you on that, or if we could work, if you could work on language, and it sounds like you're willing to. I just think it may not be used a lot, but probably less than 10% of the time, hopefully, and maybe not even that much, but it seems like we can just, have it reset everything to the way it was upon the filing, assuming it comes back eventually deemed legitimate. And so anything we can do to make this process quicker and less painful for the parties that are subject to the fraud, I think makes sense. I see on these advertisements on TV all the time, I have people talk to me about deed theft. And it's kind of the same idea where somebody fraudulently takes your deed information, files a new deed with fraudulent signatures in taking over ownership. I've never experienced that. I've only heard most people talking about the fear of it. So I don't know how often it is, although I have talked to a banker or two that have seen it coming through their line of work. And I've raised this not because it's what this bill exactly does, but it seems like it needs the same remedy as this, because in talking through the deed issue and at least the fear that's talked about in the legal world is it's very difficult for the homeowner to get the remedy without the burden being saddled on them to go back through and clean up the whole mess they were created. And it seems like the statute here and there should give the default to the person that filed it correctly and was the correct owner, and the process should default back to that. And so maybe this is a helpful way that we start looking at some of the deed fraudulent deed transactions or identity theft that's going on as well. And it seems like these are very synonymous solutions that we should try to figure out. And the recorder's offices could do the same as you at the Secretary of State's office. So happy to work with you on this as it moves forward.
Senator Limmer.
Thank you, Mr. Chair. My questions are regarding process. Perhaps the testifier could help me out. On the A2 amendment, regarding data practices, can you give me a context of where this data practice reference would fall? Is it in the form of, or to be applied in the form of an investigation, or is it in the process of a court hearing? The reason I raise this is the definitions used here for data classification. You're using the terms non-public data or private data. Usually in the terms of an investigation, that data would be in the form of confidential definition. So could you give me a little context of where this applies?
Mrs. Bethke.
Mr. Chair, members, Senator Limmer, thank you for the question. The data practices language we envisioned more in the context of data practices requests to our office and less in the context of investigations or law enforcement. The sort of idea was that, folks are likely to be submitting documents as a part of this process that might talk about, sort of sensitive business topics or personal topics. And we don't want to discourage people from making these complaints, for fear that their documents would become public through a data request. Certainly in the context of a law enforcement investigation, we would be able to release data as relevant to that investigation, which is on lines 1.23 to 1.30 of the A2 amendment. But I would say, in my view, this language does not address the sort of confidentiality classification of data as it would relate to a court case.
Mr. Chair.
Senator Limmer.
question for counsel. Does the terms non-public data or private data in Amendment A2, is it the appropriate term to be used in this context, or is confidential more appropriate?
Mr. Chair
Primo.
and members, this data framework is different than the civil investigative data framework, and that's a policy choice for the author and the committee to make. I'm guessing that some of the reason why this is somewhat set apart is that there's data being collected from potentially two separate parties, and there may be some interest that the subject of that data have in keeping it private as opposed to getting it swept into the civil investigative statute, where that data would then become public once that investigation is inactive. So if the intent is to make it non-public or private, then those are the appropriate terms to use here.
Okay. And Mr. Chair,
Senator Limmer.
in the background legislation, the original legislation, I had a question on the use of particular words on page 5 of the bill, lines 30. It makes reference to the court must be done so under restricted access unless the court orders otherwise. I don't usually see that term of art used, the restricted access. Usually there's a reference to the data classification, at least prior to that. So could you expand on what under restricted access actually means?
Ms. Primo or Ms. Bethke? Ms. Bethke.
Mr. Chair, members, thank you for the question. That language is modeled after a similar appeals process that's used in certain human services proceedings in Chapter 256. And other agencies, I believe, also have similar language when it comes to appeals of their processes. So I don't have a specific answer to that question, but it's something that we can continue to work on.
Mr. Chair, one final
Senator Limmer.
reference. The next page, line 6.3, where it says the court may consider the matter in or out of chambers. Is this common for courts to make decisions out of chamber? And would that cause a lack of transparency?
Ms. Bethke.
Mr. Chair, members, great question, and I would have the same answer. The language is modeled after a human services provision, but certainly something that we can continue to work on.
Mr. Chair,
Senator
is this
Limmer.
bill being laid over?
No, it's supposed to go to state and local government. If we need to see it back, that's fine, but it's got to get through the process.
Yeah, Mr. Chair, I'm just concerned about the out of chambers reference. It may be word of art in the health and human service area, but I'm not sure if it's appropriate in this case. I don't know.
Anyone in the room know the answer to that question? Senator Westland?
Couple of things. Thank you, Mr. Chair and members. Couple of things. On the restricted access.
Sorry,
So-
Senator Westland, on the question Senator Limmer was raising.
Yeah, it's related to that. So this is all talking about judicial review in a court proceeding, and as I am reading this, it just says the court, so whether it's in or out of chambers, they can do it formally on the record in the courtroom, or they can have a conversation in chambers about this, is how I'm reading it. So that to me is, this is all referring to the court proceeding. In the restricted access, Senator Latz, or Chair Latz and Senator Limmer, there are certain things when we file documents with the court that are confidential documents, and we are required to file them confidentially with a specific cover sheet to that, and I'm assuming that that's what this refers to.
Okay. Anyone have anything to add on that point? Senator Limmer, are you done with your questions?
Yes, sir.
All right, Senator Kroon.
Thank you, Mr. Chair.
I'm sorry, before Senator Kroon jumps in, want to make sure we give this bill the thorough hearing it needs. We are going to stay late so we can finish up the agenda, just so you can make plans accordingly, please. Thank you. Senator Kroon.
Thank you, Mr. Chair. I had a similar question about the in or out of chambers. I understand what Senator Westland's referring to. I'm just not familiar with that term of art and statute. Not saying it's necessarily bad, but I'm not familiar with it and don't fully understand the implications of it. It seems like the rules of court would govern these hearings, and the judge would have the discretion under the general rules that the judge would have. I'm not sure we need to be writing it into statute, but that's something for the author to consider. And then my other question then, I'm glad that the non-exclusive remedy was added in the amendment. That was going to be something I was going to go down, but I won't now. And then going back to page 6, lines 3 through 5, what's the reason for the prohibition of the court taking additional evidence unless the court determines that that new or additional evidence is necessary for a more equitable disposition of the appeal? I guess I would kind of rather see the judge be able to accept whatever evidence the judge wants to accept on appeal, but I'm just curious what the reason for that is.
Ms. Bethke.
Thank you, Mr. Chair, members. Yeah, it's a great question. I think the reasoning is that, in our process, we will have gone through quite a bit of information, and so there will be, I think, a lot of information available in the record. And it does, again, sort of model after similar appeals processes that are used following other agency processes in a similar way. But yeah, I'm certainly open to further discussion as the bill moves through the process.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And my only comment on that, I appreciate that answer. And the Secretary of State's office is going to be where the initial facts are presented. And I guess I kind of get it, but my only concern here is that if I were going through the process as a pro se party with the Secretary of State in the initial setting, and then I wanted to appeal to the court, I might hire a lawyer at that point, and I would want the lawyer to be able to present the evidence as that me, the pro se party, maybe didn't think to enter in the initial proceeding. So I'm a little uncomfortable with that language. Rather minor thought on my part, but something to consider going forward. Thank you.
Members, with regard to going forward, this would be the committee to resolve issues like that. So if we have suggestions for changes, we can do that. Or we can ask state and local to send it back to us to clean up what we need to.
Mr. Chair, I
Senator
could
Kroon.
do a quick oral amendment to strike everything after chambers, comma, in line 6.3 to the end of 6.5, replace the comma with a period. If Senate Council thinks that that's a good amendment, technically speaking.
Senator Limmer was contemplating an amendment that was also related to that sentence. Senator Limmer, would you like to share your thoughts on that? Might inform how we draft this amendment.
Mr. Chair, I was looking at 6.3, and after this discussion, I thought the matter could be resolved simply by striking the words on 6.3 in or out of chambers. Then the sentence would read, "The court may consider and is prohibited from taking."
My question would be whether this sentence is needed at all. I mean, you set a hearing,
Yeah.
court goes through its ordinary process of taking in evidence, considering it, and making a decision.
Mr. Chair?
Sounds a little proscriptive. Senator Kroon?
Yeah, maybe the better amendment is to strike everything after the period after hearing in line 6.2 through the end of 6.5 and just strike the whole sentence.
Senator Limmer, what do you think about that?
Mr. Chair, I think that that avoids any further confusion. I think it's more complete.
Senator Westland on that point.
Thank you, Mr. Chair. I'm a little, I don't know if council might be able to help with this, but I'm a little concerned about us. I'm trying to understand, the purposes I see of this is anytime you do an appeal, if you appeal from district court up to the Court of Appeals, you are bound by the record, right? You can't, the appeals court can't take in new evidence. We are talking about a process of judicial review of a final order that can be appealed to the district court. So you've gone through your administrative process, you're going up to the district court. And what I read this entire paragraph is dealing with is that at this hearing, you can't bring in new evidence at that point. And so I'm a little concerned about just sort of taking all of that out without fully understanding the implications of doing so. And maybe it's not that big of a deal, but that's how I understand this. So I'd love to hear if council has some feedback on that.
Ms. Primo.
Mr. Chair and members, it's a policy choice for the committee. I would say that that setup where you appeal from a district court order to a court of appeals is generally because the Court of Appeals and the Supreme Court, they don't have the same fact-finding, robust process and those sorts of resources. So it's really a choice to keep it in or not, depending on what the committee wants to provide for the litigants in the matter.
Any further discussion on Senator Kroon's proposed amendment? Senator Klein.
Senator Latz, Chair Latz and Senator Kroon, I think it's a friendly amendment.
Seeing no further discussion, all those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Westland was next on my list. Senator Westland, did you have any further questions or comments? Senator Anderson.
Thank you, Mr. Chair. To the testifier, or Senator Klein, on page 7, line 7.10 to 7.11, you delete a document and put in communication, and then it says that is sent by a non-government third party to a business, and then you delete via email or postal mail. And I'm confused as you sent, that is sent by a non, how else are we going to send it? UPS, FedEx, or how else is that communication going to be sent to the Secretary of State's office?
Ms. Bethke.
Mr. Chair, members, yeah, that's a great question. That's an amendment that arose after consultation with stakeholders, and there was some concern that these solicitations are coming via email and postal mail, but also increasingly things like text message or social media, and that those kinds of solicitations should also, not duplicate a sort of government branding and be subject to these requirements.
So, Mr. Chair.
Senator Anderson.
So text messages are okay? It doesn't say that, though.
Mr. Chair.
Senator Anderson, it looks like it's deleting the limitation, so any document sent by any means would be captured by this. If you leave the language email or postal mail in, then anything sent by some other means would not be captured by this prohibition. So
Okay.
the amendment, anything that's sent by any means would be captured by the prohibition with the correction.
Thank you.
Anything else, Senator Anderson?
Oh, that's it.
All right, any other members have any questions or comments about this bill? Senator Klein, final comments.
Mr. Chair and members, I only want to wrap up by thanking you for your time listening to it, and I should have acknowledged at the outset that this bill builds upon work that Senator Anderson started last session and hopefully will come to fruition this year.
Well, in that light, then, Senator Anderson moves that Senate File 1734 as amended be recommended to pass and be referred to State and Local Government Committee. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Klein. Senator Johnson Stewart, come on forward. Senate File 1836. Members, the plan here is to we have a change of course. The plan here is to move this bill to the floor. Senator Johnson Stewart, could you please give us a brief summary of your bill? And we have one testifier signed up.
Thank you, Mr. Chair. Committee members, Senate File 1836 would limit the authority to issue a citation to a pedestrian crossing the roadway in a variety of circumstances. Basically, it reduces the scenarios where a citation could be issued for jaywalking violations to situations where another violation is already occurring, or when a pedestrian's choice to jaywalk creates a scenario that may cause a collision between the pedestrian and a vehicle. Typical or current citations can be given for jaywalking in the following circumstances. And now I don't see it. Oh, here it is. When a pedestrian crosses a road on a yellow or red light, during a flashing or steady display of a don't walk signal, or in the middle of a block between intersections with operational traffic signals. So again, it removes the ability to issue a citation in those cases only if the pedestrian is stopped for, or unless the pedestrian is stopped for an unrelated violation or the pedestrian is causing a hazard to an approaching vehicle. Mr. Chair.
Thank you, Senator Johnson Stewart. Your testifier. Sir, go ahead. I don't want to mispronounce your last name, so you go ahead and tell us what it is.
Mr. Chair, members, my name is Michael Wojak. I am the Executive Director of the Bicycle Alliance of Minnesota. We are Minnesota's premier statewide advocacy and education organization focusing on making sure all Minnesotans can safely bike, walk, and roll. We come here to speak in favor of this bill, and I must begin by acknowledging that I sit before you as a hardened criminal. In fact, when I go up to visit my mother in Hibbing, I oftentimes park across the street from the Sunrise Bakery, and I then cross the street and go to the bakery and get a very delicious pastry. By the letter of the law, I have committed a violation. However, I'm doing something that is in fact quite safe in that particular location. What we are trying to do is come up with some common sense language to bring Minnesota statutes consistent with what people's practices actually are. Now, I was going to ask you to raise your hand if you've jaywalked before, but I do, too fast. But I do want to respect your constitutional right against self-incrimination, unless you've already done it, of course. So a little bit about the technical parts of this bill. What we're doing in this bill is we're specifically saying if you're doing something that's unsafe, it's still on the books, that's still the violation, you're responsible for that. We also, we're interested in engaging with the law enforcement. We've talked to the Department of Public Safety, who's not opposed to this. We've also met with the Police Chiefs Association. Haven't heard back from them. They had some questions that we were following up on, but as of this morning, haven't heard back. We're delighted that we can bring forward this bill as a common sense measure with bipartisan authors, and I think that speaks to what we're hearing is that, as Senator Jasinski said, this is a common sense bill that reflects what people are actually doing. I'll just leave it at that. I know you have a busy schedule, but I'd be happy to answer any questions that you might have or just take general complaints about e-bikes or whatever else.
No.
So I'm going to channel Senator Limmer here and say that if you didn't bring any donuts pastries from the Sunrise Bakery, you got limited chance of passing the bill here tonight.
Thanks a lot.
Don't answer that. We don't want you to incriminate yourself. Any members, anyone in the room want to testify for or against the bill? Any members of the committee have any questions or comments about the bill? Senator Clark, would you like to move Senate File 1836 be recommended to pass and be re-referred to the Senate floor?
Proudly. So moved, Chair Latz.
All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Johnson. Stewart.
Thank you, Mr. Chair and committee members.
All right, Senator Kunesh has arrived.
My pleasure.
We're going to do Senate File 1627. Senator Kunesh, if you would give us a brief summary of your bill, please.
Yes. Good afternoon, everybody. The bill before you, Senate File 1627, seeks to update and improve the American Indian cultural programming requirements within the Department of Corrections. The current statute 241.80 has been in place since 1985, with only one minimal revision since then. This law contains outdated and, in some cases, offensive language, as well as provisions that no longer serve the needs of Native American individuals within Minnesota's correctional system. For example, the bill proposes to remove requirements such as the teachings of good work habits and adjustments to cultural differences, and replaces them with language encouraging education and training and partnership with tribal nations. Native Americans make up approximately 1% of Minnesota's population, yet they represent over 9% of the state's incarcerated population and 25% of the female incarcerated population. This overrepresentation highlights the need to be targeted, culturally relevant in programming. Today we have with us Commissioner Paul Schnell from the Department of Correction to testify in support of this bill.
Commissioner Schnell, please give us your succinct testimony.
Mr. Chair, Chair Latz, and members, I will make this very simple. This proposal was really brought to our attention during consultation with tribal leaders from across Minnesota, who identified their significant concerns with the statute's language. And really what they wanted to do was to recognize the fact that research shows that culturally relevant programs help reduce recidivism rates, and incarcerated Native Americans who engage in culturally specific and relevant programming have lower recidivism rates compared with those who do not. These programs, whether they're mental health, strengthen cultural communications and contribute to the overall well-being of our Native American neighbors. With that, Mr. Chair, I thank you for the opportunity to testify, and I appreciate being here to speak on behalf of the leaders and Native American people who provided input into the language before you. Thank you.
Thank you. Any questions or comments from members of the committee? Not seeing any. Senate File 1627 is laid over for possible inclusion. Senator Kunesh, Senate File 942.
Thank you again. So this bill requires, well, currently, Minnesota state law requires local child welfare agencies to implement traditional child protection responses for screened-in child protection reports of education neglect. And that is defined as 7 unexcused absences for children under the age of 12. A traditional child protection response automatically triggers a fear response for parents, and their child will be removed from their care if they don't find a way to get their kid to school. This is not proven to be a meaningful intervention for a long-term solution. We know that the barriers commonly at the root of attendance concerns are things like housing instability, transportation barriers, lack of reliable child care, cultural and language differences, unmet mental health or medical needs of the child or family members, financial stress, lack of trust or relationship with the school, and many other unmet needs. So in other words, school attendance is less often an issue of parental neglect, but rather an issue of societal neglect, where our system is failing to support children and their families. We can improve student attendance in Minnesota by implementing responses that are less punitive first and seek to address those actual barriers. What is keeping those students from getting to school? That's really what we're trying to get at. So what are those actual barriers to the child and the family? And what's getting them, what can we do to put resources in place? So this bill would allow local welfare agencies to implement a child welfare response versus a traditional child protection response. Those are two very different things. This change would allow local welfare agencies to utilize community-based providers, family resource centers, or county attorney's office as a diversionary response. If the family does not engage in the diversionary response, then the traditional child protection response could be initiated. Services must be culturally and linguistically appropriate, and funding is requested to help local welfare agencies implement a diversionary child welfare response, like a pilot program. That might include program evaluation to demonstrate program effectiveness so that more programs can be implemented statewide. This summer, we had an attendance team or task force that was looking at attendance and why there are such a high rates of attendance across the state. And one of the things that we found is that there are a lot of barriers that cause a child not to show up to school. And there's also ways to address those barriers to prevent really permanent harm to the family, like having the child taken away. So with that, I have a couple of testifiers, Mr. Chair.
Thank you, Senator Kunesh. We have Michelle Miller is joining us online.
Yes, thank you for having me today. My
Ms. Miller,
name is,
thank you for joining us. I'm just going to
Yes.
note it's 2:35. We've got about 15 minutes left, and we've got one bill after this one. So we want to make sure we give due consideration to this bill. But if you could be as succinct as you can with your testimony, we'd appreciate it.
absolutely.
Go ahead.
Thank you for having me today. My name is Michelle Miller. I serve as a Child and Family Services Manager for Wright County Health and Human Services. One of the important points Senator Kunesh mentioned is that educational neglect is not an issue of child safety, which requires a child protection response. This is an important distinction and one that Wright County has recognized, successfully addressing attendance issues using a child welfare response since 2011. As we know, child protection involvement carries a heavy stigma. Parents are fearful of becoming involved in child protection, of potentially having their child removed from them, and as a result are reluctant to work with a child protection social worker. Maintaining a child protection response to the issue of school attendance sets up an automatic obstacle for families that are likely already experiencing numerous obstacles. Over the years, Wright County has seen that the biggest challenge to families is mental health, whether that be of the parent, child, or both. Couple that with other difficulties such as financial stress, trauma, etc., and then layer that with child protection involvement, makes for a mismatched response to school attendance. Our experience has been affirmed by the Wilder study of ed neglect diversion programs in Minnesota. 63% of parents stated their child had emotional or mental health concerns, and then financial stress topped the list of challenges parents are experiencing. By using a child welfare response, we can lessen the fear associated with working with a county social worker and more easily come alongside families to support and engage parents to get to the root cause of attendance concerns. This working relationship is so important to developing strategies with families and their networks to address the barriers, which then helps set up their child for school success. Our data shows that the earlier we can become involved with families experiencing attendance issues, the greater success we have at getting the student to school. Thank you for your time.
Thank you, Ms. Miller. Dr. Ndumbe?
Dumbe, the N is silent.
Thank you. Dr. Ndumbe.
Thank you, Chairman. If I have to reference some of the points made by Senator Kunesh and my colleague Michelle, you can see that unemployment, 36 based on the Wilder Foundation, 36% of the respondents reported that unemployment and financial issues were barriers in terms of school attendance difficulties, intensive work schedule, issues of co-parenting, mental health, emotional well-being, transportation, housing instability. None of these aspects we hear today is related to egregious harm, which is traditionally handled by child protection. So as we look forward to bringing this bill forward, we're thinking about the families who are experiencing educational concerns because of these contributing factors, and wrapping around support for these families by removing these barriers, which appear to be long-term, can only create long-term stability, not just for one family, but for generations of families. A single mom 2 years ago met me at a back-to-school rally, ran up to me and gave me a hug and said, I just found out you are the program manager for the PACE program. Thank you for what you do behind the scenes to support my children. If not for you and your program, my kids will not be at home because of my mental health. My kids are going to school. They are not doing very, very well, but they are doing well enough to experience positive educational outcome. I hope you take this into consideration and support families who are experiencing educational concerns. That long-term strategies does not include child protection. Child protection is really dedicated for severe, egregious harm and safety. Thank you, Chairman.
Thank you, Dr. Dumbe. All right, there is an A4 amendment here.
Oh, you're right.
Senator
there is-
Kunesh, would you like to tell us about the amendment?
The A4 amendment removes the references to truancy in this bill and changes them to educational neglect, as the intention of this bill is educational neglect cases that trigger a child welfare response.
Any questions about the amendment from members of the committee? Senator Limmer.
Thank you, Mr. Chair. Sir Kunesh, could you tell me, is there a consequence when someone triggers the educational neglect charge? Is it a, I don't know what it is. Is it a criminal violation? Is it a civil? Are there fines? Or is it just validates a report to a different child authority?
Senator Kunesh.
I'm going to ask Dr. Here to respond.
Yeah, thank you.
Dr. Dumbe.
Yeah, thank you. Thank you. I am honored to work alongside my child protection task force. And yes, if there is chronicity in absenteeism, then it can be referred to CHIPS, which the children can be removed from their home currently as the consequences of not going to school.
Mr. Chair,
Senator Limmer.
could that be triggered after a 7-day absence, that charge?
That it would change from,
Senator Kunesh.
I'm so sorry, habitual truancy to child
Educational.
neglect?
Yeah.
Senator Limmer.
I believe in this bill it does, doesn't it?
Kunesh.
Yes.
So, Mr. Chair,
Senator Limmer.
if let's say my child was smart enough to avoid me, and I didn't know he was going to school for 7 days, I could be charged with educational neglect, and my child could be taken from my home.
Go ahead.
Yes, Senator, and I think,
Dr.
yeah,
Dumbe.
I think from the bill standpoint, we want to be able to differentiate the children between the age 12 and under, because that is really, the burden is on the parent to get the children in school. What I'm hearing you say is the child who can avoid, that's the truant. That is 12 and above, where they can now make decisions, either they say they're in school, but they are not in class. So I think this bill is referencing the cases of the children who are really under the supervision of the parent. If they don't go to school, what is the consequences for the parent? So absence continuously can lead to either CP response, which the child can be removed from the home, but it goes through the court proceedings.
Mr. Chair,
Senator Limmer.
if a parent knew that their child was not going to school and simply came to the conclusion that the parent didn't think that it was any business of the school district to know a reason why, is that a violation, or would that qualify as educational neglect? even though the parent knew that the child would be at home?
Dr. Dumbe.
That would be correct, because that is, the parent is aware that it's lawful for a child to go in school, and the parent now is making a decision in the absence of all these barriers we listed, not to educate the child, so yes.
And Mr.
Senator
Chair,
Limmer.
just a question for council. Is there a legal definition of educational neglect in statute? And does it also include the penalties?
Ms. Primo.
Mr. Chair and members, I believe there is some language, but I'll need to look that up to get the specific reference.
Mr. Chair, one last question.
Senator Limmer.
Is the 7-day factor, is that something new that we're putting into statute via this bill, or is that an existing standard?
I think that is currently what the statute says, that's 7 unexcused absences.
All right. Thank you.
Any further discussion on the A4 amendment? Senator Westland moves adoption of the A4 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. We'll give Ms. Primo a moment. Whenever you're ready, if you can be. Ms. Primo.
Mr. Chair and members, I'm searching Chapter 260C for the specific educational neglect, like the term, but that term is not defined in that statute. There is language about neglecting education generally, so I don't find something that I think you're looking for in terms of a specific definition.
Mr. Chair,
Senator Kunesh.
I just looked it up, Googled it. In Minnesota, educational neglect, a form of child neglect, is defined as a parent's failure to ensure their child attends school as required by law, specifically when a child under 12 has 7 or more unexcused definition. And so a child's absence from school is presumed to be due to the parent's failure to comply with compulsory instruction laws if the child is under 12 and has 7 or more unexcused absences.
Seeing no further discussion, the appropriate motion here is to refer Senate File 942, be recommended to pass and be re-referred to the Committee on Education Policy as amended. All right. Senator Verbetten, so moved. Senator Limmer on that motion.
I'm sorry, I want to ask one last question.
Please do.
Senator Kunesh, you read a definition. What's the source of that definition? Is that in the statute?
Oh, crumb, I just lost it. I'm sorry. It is,
Ms. Kunesh, Ms.
Yes.
Primo has something to offer.
okay, great.
Mr. Chair and members, it sounds like that language may have come from 260C point, it's cited in the bill in one of the definitions, but it's the presumption of educational neglect. So it doesn't define it, but it says, here's the presumption of when a child, when there's certain presumptions against a parent, when a child is under 12 versus a child is over 12.
All right, Senator Verbetten moves that Senate File 942 as amended be recommended to pass and be re-referred to the Senate Committee on Education Policy. All those in favor say aye. Aye. Opposed? No. Motion prevails.
Okay. Now I found it.
Thank
Okay.
you, Senator Kunesh.
Thank you so much.
Members,
Chair.
last bill of the day. Mine, we'll have Senator Seeberger. Can you take over the chair?
All right, Senator Latz, when you're ready.
Thank you, Madam Chair and members. Senate File 1719 would establish a task force on mandatory minimum sentences. As this committee is well aware, mandatory minimum sentences have been a topic of conversation in a variety of bills that have come through here for many years now. We've had various viewpoints on how helpful they are, and whether it's appropriate to set statutory sentencing standards in addition to Sentencing Guidelines Commission standards for sentencing, and so on. I think it's high time that we have a task force take a look at the impact of mandatory minimum sentences, and that's what this bill does. It establishes a task force to accomplish just that. It sets out the membership of that task force. It identifies how the task force should be organized. It identifies their responsibilities, including data to collect, input to receive, and to analyze in the light of a variety of criteria, and then provide a report back to the legislature by next January 15th, although we're going to actually change the report date, so there's more time to accomplish that. So that's the long and short of it. We do have some testifiers, but before we get to that, I'd ask that we adopt an author's amendment. I'm going to make the primary amendment the A2 amendment and incorporate in that the language in the A3 amendment as well. It adjusts some of the membership of the task force, and it gives additional time until the following August. So there'll be about a year for the task force to do its work. That's at the request of a number of interested parties. And then also adds to the membership, as to the criteria and from whom input should be received. A couple of members are criteria for that, including victims of crimes and family members of victims of crimes that where mandatory minimum sentencing was involved in the criminal consequences. So I move the adoption of the author's amendment as indicated.
Senator Latz moves the adoption of his author's amendment. All those in favor say aye. Aye. Any opposed? The amendment is adopted. I'll invite one of your who's, we got Ms. Brisbois.
You get the French Canadian.
Brisbois? Okay, you may introduce yourself for the record, please, and begin your testimony.
Thank you. My name is Jill Brisbois. I'm here on behalf of the Minnesota Association of Criminal Defense Lawyers. Thank you for the opportunity to testify in support of Senate File 1719. Mandatory minimum sentences have a profound effect on our criminal justice system, often limiting judicial discretion and leading to disproportionate outcomes. While these laws were originally intended to ensure consistency and deter crime, they also result in unjust sentences that do not take into account individual circumstances or the complexity of each case. This is why the formation of this task force is critical. By collecting and analyzing data, hearing from impacted individuals, and reviewing best practices from other jurisdictions, the task force can provide an evidence-based assessment of whether mandatory minimums are effectively promoting public safety and fairness. A thorough review will allow us to determine whether these laws are achieving their intended goals or if reforms are necessary. Our participation as criminal defense attorneys is essential to this process. We have firsthand experience representing individuals affected by mandatory minimums and can provide crucial insight into how these laws operate in practice. Our perspective will help ensure the task force considers the real-world consequences of these sentencing policies, particularly regarding the impact on judicial discretion, racial disparities, and rehabilitation opportunities. We urge this committee to support Senate File 1719 and the creation of this task force. A comprehensive and balanced approach to sentencing policy is necessary to promote justice, protect public safety, and ensure that the punishment both fits the crime and the individual circumstances. Thank you for your time, and I'm happy to answer any questions.
Thank you, Ms. Brisboy. Our next testifier is Lindsay Sicola. Go ahead and introduce yourself for the record and proceed.
Good afternoon, and thank you, Mr. Chair, members of the committee. My name is Lindsay Sioka, Chief Public Defender for the 1st Judicial District, speaking on behalf of the Board of Public Defense. Thank you for your time. I know it's been a long afternoon, so I'll keep my remarks as brief as possible and not repeat those, as my colleague, Ms. Brisboy, just mentioned. Again, speaking in support of Bill 1719, establishing a task force examining the effectiveness of mandatory minimum sentences. Cases sentenced pursuant to mandatory minimum sentences have some of the highest rates of departure in our state. These are both dispositional and durational departures. This shows that when examining the facts of the case combined with the individual before them, some judges are finding that the mandatory minimum sentences are not justified and are overly punitive. However, there are significant geographic disparities in the rate of departures. Individuals may be more likely to receive a departure from a mandatory minimum sentence or be sentenced to prison depending on the county where their case is being heard. This disparity creates the troubling issue of justice by geography. Mandatory minimum sentences can often limit negotiations between a prosecutor and a defense attorney who may want to find the right resolution for the specific facts and individuals involved in a case, which may include the rights from a victim, and they are limited by mandatory minimum sentences. This expands to judges who would impose a more lenient sentence based on the agreement of the parties, but there is no legal mechanism around a mandatory minimum sentence. As a collateral consequence that should be studied should this task force be created, are that individuals sentenced pursuant to mandatory minimum sentence are not eligible for rehabilitative programs at the Department of Corrections, including the Challenge Incarceration Program. Frequently, individuals sentenced pursuant to mandatory minimum sentences are often the best candidates for these programs, which would decriminalize their behavior and their thinking. These rehabilitative programs better prepare individuals for re-entry into the community and make them more successful upon release, and those sentenced pursuant to mandatory minimum sentences are not eligible for this program, and they do not have access to this. Data and research on mandatory minimum sentence would inform the legislature on important questions such as whether mandatory sentences are effective in protecting public safety, or if there are additional socioeconomic or racial disparities that need to be addressed. Of particular interest would be the rates of recidivism for individuals who were sentenced pursuant to mandatory minimum sentences or who received departures to determine whether or not mandatory minimum sentences are effective in protecting public safety or if they are unduly punitive. Thank you for your time, and I will take any questions as well. Thank you.
Thank you, Ms. Sioka. Any questions or comments from members of the committee? Seeing none, Chair Latz.
Madam Chair, I just want to note you have in your packet letters from the Minnesota Justice Research Center and the Center of the American Experiment. The amendments have addressed some of the points that were raised by each of those entities. So trying to address the concerns of stakeholders as we move forward with this. With that, why don't you tell me, Madam Chair, I think it goes to state and local government from here, and then we're expecting it to come back here because there is a funding component to it. So I move that Senate File 1719 as amended be recommended to pass, be re-referred to the Senate Committee on State and Local Government.
On Senator Latz's motion, all those in favor say aye.
Aye.
Any opposed? Motion prevails, and it is on its way to state and local gov. Announcements. Tomorrow, the judicial branch reception, is from 2 to 4 p.m. in the Supreme Court chambers. I like that one. And there being no further business before the committee, we are adjourned.